we're still gonna debate it with the entire committee for recommendation to the report, then to the House. I then agree with you. We've already, let me welcome everyone in this platform, especially our presenters of today, that to take their time and also to put together documentation that they want to raise with the members of parliament. This is much appreciable. Colleagues and members, we are today gonna to hear 3 presentations. The first one will be presentation that comes from Councillor of Advancement of South African Constitution, of South African Constitution, CASAC. They will be the one that will be giving us they will be presenting to us today. We will just hear their presentation. We want to thank them once more again for them to avail themselves to ensure that they present this document to us for us to understand and also to engage with it thoroughly. We can assure them that all the deliberation that they are going to engage with us will be noted and also will be discussed with the full committee for recommendation into our report, then into the House. Thank you very much. Let me check with you, Pilot, first as to is everybody that we are expecting in our presenters are here. Mr. Naido, Lord Naido, Mr. Matome, Chidi, and Kuso Selowa, the director.
Yes, Chairperson.
Are they all in here?
Yes, Chairperson. The first would be from CASAC. Mr. Naidu is there. Maybe he will introduce his delegation through you, Chair, so that and then they will take us through.
Mr. Naidu, thank you very much for your time. Thank you very much, Mr. Naidu, for taking time and compile these documents and ensuring that it gets through to us on time. And also, we will be ready just for your engagement in this matter. Now we will give you at the maximum of 30 minutes, but there's no crime to do it even in 10 minutes. But your maximum will be 30 minutes. Mr. Nada, thank you very much. I think I've seen your face actually in the constitutional review in Pretoria. Yeah, thank you very much once more again. You are welcome in this meeting. Feel free. Raise whatever matter that you want these members of parliament to understand that you feel it was a gap in our constitution that need to be taken into consideration. You're welcome, sir. The platform is yours. You will introduce your delegates, people that are with you there, whether they're also virtual with you in the office. We will appreciate to know who else are with you. Thank you very much, Mr. Naido. Let me hand it over to you.
Thank you very much, Honorable Chair, Honorable Mtetwa. It's a real privilege for us to be here this morning to be able to present the submission that we've made to the Constitutional Review Committee. I'm joined this morning by my colleague, Mr. Dan Mafora, who will take us through the presentation shortly. I just wanted to preface that presentation. Obviously, you will have received our submission and have looked at it already. But by way of background, you know, the submission that we make is based on a report of an ad hoc committee that was submitted to Parliament in 2007. An ad hoc committee that was chaired by the late Professor Kader Asmal, looking into the structure of Chapter 9 institutions and their efficiency and effectiveness. Professor Asmal was one of the founding members of CASAC in 2010, shortly before he passed away. This is an issue that I think has been on Parliament's agenda for some time, of dealing with this the so-called Asmal report. Those of you that may have been present at the Constitution on the conference that was convened by the Department of Justice last week in Midrand will also note that this was an issue that was raised and discussed during that conference. So I think it's really timely that we have this opportunity to make this presentation to the committee today. The issue, as I say, of the Asmal report has been on Parliament's agenda for some time. It's found its way into various handover reports from various parliaments, from the 3rd to the 4th and through to the 6th, I think. And we certainly hope that the 6th Parliament will, in the time that it has left, take some steps to move the discussion on the Asmal report forward, and particularly in regard to the proposal that we are making today, which is around the creation of a single human rights body. You will also be aware that Parliament did call a few years ago for similar submissions on a single human rights body. There were, I think, several public submissions that were received in this regard. So I think this is really now an opportunity for us to properly engage in the submission that we're making, based, as I say, on the Asmal report. And we look forward to the engagement with you this morning. I can assure you, Honourable Chair, we will probably not take up our full 30 minutes, because I think the submission we make is relatively straightforward. And I'm going to hand over now to my colleague, Mr. Dan Mafora, to take us through that presentation, with your permission, Chair.
Thank you very much. Thank you very much, Mr. Naida.
Good morning, Chair. Good morning, members of the committee. My name is Dan Mafora. I'm the senior researcher at CASAC. I don't know, Chair, if the presentation can be flighted.
Yes, there are means of doing that. Let me check with Pilot.
Chairperson, Mr. Mafora can flight. I've made him a co-host, so he has got the rights to flight the presentation. If he can go to share screen, and then he will be able to flight.
All right, thank you.
Is that possible, Doc?
Yes, I am just going to do that now, Chair. I'm not sure if that's visible.
Yeah. It's in order.
Thank you, Chair. So as Mr. Naidu has already mentioned, we base this submission on the Asmal report that was commissioned and delivered in 2007 on the restructuring of Chapter 9 institutions. And you'll see there that there are two institutions, the Pan-South African Language Board and the National Youth Development Agency, which are obviously statutory bodies and not Chapter 9 institutions, but which have the same or similar kind of mandates that overlap with some of the Chapter 9 institutions that we have identified, being the Human Rights Commission, the Commission on Gender Equality, and the Cultural, Religious, and Linguistic Rights Commission. Now, the idea or the findings of the Asmal report were that there were a couple of inefficiencies, duplications of roles and functions, and a general kind of bloating of these institutions, and which affected their effectiveness in carrying out these missions, which resulted in certain discrepancies or disparities in how they approached their roles, and that this could be solved by amalgamating, merging them into one single human rights body. And that is the position that CASAC has taken in relation to this matter. And of course, the recommendations were that this human rights body would reduce duplication of roles due to the overlap of mandates, optimize the allocation of human and financial resources, be more accessible to the public by having just one place where you would have to go to lay a complaint, and have that kind of have the resolution of your complaint sorted out in one place, where, for example, the alleged violation or whatever else is happening can be dealt with in a more integrated and interdependent way, instead of having kind of a siloed approach where even if your complaint implicates, say, gender and religious rights, you'd have to, under the current system, lay different complaints at different institutions. Whereas if you had a body like the one that we are suggesting, you would have the one place that you go to and have it dealt with in a holistic way. And of course, this single human rights body would be accountable directly to Parliament as well. Now, we, like I said, fully support the ASMAL report and believe that it should be implemented. And we propose the following, that is that it would have demarcated focus areas. So where you have, for example, the Gender Commission, would be integrated into the body as a unit, as a unit that functions under the umbrella of the single human rights body. The idea here is that we do not want to lose the expertise and the kind of institutional memory that has been built over the years in the creation of this single human rights body. So what you would have then is a single body that functions as one whole instead of different institutions performing the same or similar functions. And of course, we believe that there should be provincial and regional presence. I am not quite sure about the spread of for example, the Cultural and Religious Rights Commission, but the proposal here would be that because some of the other Chapter 9 bodies, like the South African Human Rights Commission, have a broader spread, a greater reach in the Republic, they would then, in the creation of the single human rights body, be able to expand the reach of the other institutions that may not have the same kind of reach. And that would also help with visibility to the public, and for them to understand that they have an avenue to pursue any claims of human rights violations that they have. And of course, we also propose that there be a formal system of the transfer of complaints from one body to another. So for example, if one were to lay a complaint at the Public Protector's Office, which that institution decides, it's something that's out of their remit or out of their jurisdiction, they would be able to formally and seamlessly transfer it onto the correct body instead of turning the public away and the public having someone having to go bring a whole new claim at the correct institution. And of course, we believe that, like the current Chapter 9 institutions, they should be, this body rather, should be independent from the executive, and that the independence provisions be similar to those that we have in Section 181 of the Constitution. There will need to be a rationalization of the number of commissioners for the single human rights body, because as we know, there are varying numbers depending on the institution, its size and its functions, and we would need to consider the size of this institution, whether you keep the current number, for example, of commissioners at the Human Rights Commission, the existing one, or if you were to enlarge it to include some of the to accommodate some of the new functions that this body will acquire. And we detail there that from our calculations, having looked at the different legislation, we have seen that there are at least 58 commissioners and directors in these institutions across the board, and that in order for this institution to be streamlined, there would need to be a process of natural attrition. And for that, we say, for example, that if vacancies occur, they should not be filled while we're in this transitionary period. But of course, once we have the single human rights body, we would need to appoint commissioners and directors or directors who have the requisite skills and experience that covers the range of the areas that these different bodies currently serve. And you'll notice that we have excluded 3 or 4 Chapter 9 institutions, that's the Auditor General, the Public Protector, the IEC, and CASAC, because they serve very distinct roles from the commissions and the institutions that we have identified. And so there will need to be a need to balance the experience and expertise of the commissioners that would be brought into this new body, along with the kind of streamlining of the institutions that exist today. And then we deal, secondly, with the appointments. Obviously, criteria and the process must be clearly spelled out. Again, emphasizing experience and expertise, because this will need people with experience in the areas that are currently covered by these 5 institutions. That we secondly recommend that these appointments must be for fixed term, and consider the need for continuity, right? So perhaps you could have staggered terms, appointments maybe midterm of the existing commissioners to ensure that there is that transfer of knowledge and institutional experience over to the new appointees. We also propose that appointment process be an open parliamentary process, including the appointment of the chairperson, and that they be directly appointed by the National Assembly by resolution instead of delegating that power to the president or a minister. And so we believe that this is a function that Parliament itself should perform. We also propose that remuneration be standardized. In our observations, we have seen as well that there is a disparity in how remuneration is determined across these institutions. And of course, we propose that there must be a formal provision for the participation of civil society in the appointment process. You will know that civil society engages quite a lot with Chapter 9's institutions and have an experience of what works and what doesn't, and the challenges that these institutions face. And we think that this is an opportunity for Parliament bring civil society into the fold and allow them a greater role in assisting in the capacitation of these institutions. And there would also need to be a serious consideration to the allocation of roles between the staff and the commissioners. If we were to consider the commissioners to play more of an executive and managing role, instead of more operational, Parliament would have to give serious consideration to that, to make sure that the staff that are going to work in this single human rights body have clear and defined roles that are distinct from the roles that are to be played by the commissioners, to avoid the kinds of challenges that we've seen in some of these institutions where there seems to be confusion about what the proper role of commissioners is meant to be. Finally, on oversight, we believe that the relationship between the single human rights body should be clearly defined, especially in relation to the appropriation of funds via Parliament for its operations and parliamentary oversight over its function. We consider that important as an aspect of independence, that this institution would not have to rely on the budgetary processes of any government department, but that its monies would be directly defrayed by Parliament. And finally, we submit that a portfolio committee that specifically looks at Chapter 9 institutions should be considered, specifically because currently different Chapter 9 institutions report to different portfolio committees, and that has created some confusion about what the reporting expectations are on the part of the Chapter 9 institutions. So a single portfolio committee structured in any way that Parliament sees fit, obviously considering the different roles and functions of these Chapter 9 institutions, should be considered as an oversight mechanism. Finally, in closing, Chair, we again reiterate that Parliament must act with some urgency on the implementation of the ASMAL report. It was first commissioned in 2007. And I believe a few years ago, 2018, if I'm not mistaken, the Office Supporting Institutions of Democracy brought it up again to call for submissions from the public on how this matter should be taken forward. And we believe now that is the perfect time for Parliament to seriously consider undertaking this process of constitutional reform. One last thing, Chair, is that the single human rights body would need to kind of have a dual role, one to promote respect and protect human rights and to monitor the observance of human rights by the state, but also to vindicate individual rights where those claims are brought, following a process of a complaint being laid and so forth. So we think that it will play a greater role, for instance, in awareness in public education about human rights and about the role of the Bill of Rights in our democracy. And we think that is an important function. Chair, I believe that you have the full submission. We will be happy to take questions, of course, and to provide any further clarification if it's needed. Thank you.
No, thank you very much, Dan, for your presentation. Let me check first to Mr. Naido if there's anything he wants us to add before I open the platform to the committee members.
Thank you, Honourable Chair. I've got nothing further to add. I think my colleague has summarised the submission for your benefit and those in this meeting. And we look forward to any questions or comments that you may have. Thank you.
Okay, thank you very much. Members, I think now is time to ask any seeking clarity question or question of understanding through the document. And again, I must emphasize that we do have these documents we have gone through. We still had to discuss this in detail, but all what it can help us now is that the authors are here just to clarify your own understanding in reading the documents. Let me give it to members in the platform. We will assist me, highlight if you see a hand, because it's difficult on my side here to see who has raised a hand in the next 5 minutes. Over to you, colleagues. Do you see any hands, Tyler?
No, Chairperson, there is no hand. There is the member that is in the platform is Honorable Maleka.
Okay.
Yeah.
Now let me then come in. I hear you then talking about that this single human rights commission, it must have its own for portfolio committees. How do you think that portfolio committees must be formed? Do you have any idea how that portfolio committee must be formed? And secondly, I want to also to understand that you mean to say that that portfolio committee must oversee all the issues of the Chapter 9 institution, or they are, because you will understand that there are different roles in the Chapter 9 institution, and then how is that gonna be synchronized into one portfolio committees? Do you have an idea on that?
Thank you, Chair. I think that that's a good question about the portfolio committee. The idea is that perhaps the IEC and the Auditor General serve quite distinct purposes, and maybe they shouldn't report to this portfolio committee. But what we are thinking of is one portfolio committee that oversees these Chapter 9 institutions. So not just this single human rights body that we are suggesting, but the public protector as well. And I'm not sure how portfolio committees are formed in Parliament. That might be an interesting thing to look into. But obviously, it's up to Parliament to decide how to structure it and ensure that there's representation for all of the parties proportionate to their share of seats in the National Assembly. And then the second question, sorry, I missed that one, Chair, sorry.
Yeah, maybe let me also put it that way. Also, you mentioned the issue of staffing that is there. You said that staffing, the only way to phase them out, you suggest that whenever there are people that are retiring, must not replaced. Do you think how long this process can take you? If you wait for people to retire or to leave the system by one way or other, how long do you think it's going to take the institution to be implemented, your proposal?
If I may come in, Chair, on this, and perhaps just to start with the first question about the dedicated portfolio committee for Chapter 9 institutions. You will recall that this is an idea that was first postulated in a report prepared by Professor Hugh Corder in 1999, looking at the oversight functions of Parliament. It was an issue that also gained some airing during the proceedings of the State Capture Commission of Inquiry. And I believe that one of the recommendations in the report of the State Capture Commission in the section on Parliament also makes reference to such a committee. I think my colleague Dan is correct, because where you have institutions like the Electoral Commission or the Auditor General that have very specific defined functions, and there are line departments that are responsible, it would be appropriate to retain those. But the argument for a sort of overarching portfolio committee on Chapter 9 is to ensure that the reports from all of these bodies receive due attention by Parliament, and that Parliament takes up the issues and the recommendations that they make. In relation to your second question about the staffing, and it's more around the commissioners of the various Chapter 9 bodies, I think, as my colleague has explained, there are a large number of commissioners across all of the bodies at the moment, and obviously that would have to be rationalized. So the first thing would be for Parliament to consider is what is the optimum number of commissioners for a single human rights body. And if we say, for example, it's a figure of 12 commissioners, and currently we have over 50, and then you'd have to have a process of natural attrition. And I think one would then have to look at the detail of the tenure of each of those people to see when we would reach that position. And if it's going to be too long a transitional period, then Parliament may need to consider some other mechanism to truncate that process, to say, well, all of these positions are going to be terminated at a particular point, and that a new body will then be established on that basis. But that's some of the detail which I think Parliament might need to grapple with once it gets into the detail of establishing such a single human rights body. Thank you.
No, thank you, Mr. Naidu. But I also suggest that, don't you think that it's therefore, in your presentation, it was going to be good that you indicate the Chapter 9 institution that can be synchronized together. You, as an example, you just say this and this and this Chapter 9 institution, according to the reports and to our views, we think this can work together, because currently all the Chapter 9 institutions, they belong to different committees. So don't you think that your report need to indicate that, so that we don't just go all over the issues? Just be specific that your proposal is based on this one and this one and this one. Don't you think that this report can assist us in doing that way? Mute, Mr. Naidu.
Sorry.
Mute yourself.
Yeah, I've unmuted. Thank you. No, I think you're absolutely correct, Chair. And I think Dan touched on this in one of his early slides, where we say that the USMAL report recommended the establishment of this body, and that it would comprise the following institutions: the South African Human Rights Commission, the Commission for Gender Equality, Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, and then to add two statutory bodies that are not currently Chapter 9 bodies, which is the Pan-South African Language Board and the National Youth Development Agencies. So those 5 bodies are the 5 bodies that we're focusing on to be restructured into a single human rights agency. And I think the USMAL report was also quite clear that those were the institutions that we are looking at, and not, for example, the Public Protector, the Auditor General, or the Electoral Commission, which perform very different functions. So this is really around trying to group together the human rights institutions in Chapter 9 and statutory body.
No, thank you very much, Mr. Naidu. Let me check, Pilot, is any other hands so far?
No, Chairperson, there is no hand that I can see.
Okay, thank you very much. Mr. Naidu and Dan, thank you very much for this presentation that you have given us. You have enlightened us to some of the things that we were reading. I think now we will read with more and more clear understanding and the proposal that you have presented to us. We really appreciate this, and it's going to assist us in crafting our report as we take it forward to the House. And we obviously are going to air our own views when the full committee met, and then you'll be liberty to get that views at the end of the day as to how the committee is viewing your presentation. May I give you the last closing words in this meeting, and thanks again for your contribution as well.
Well, firstly, Chair, let me say thank you to you for accommodating us this morning, engaging with us on this work we believe is a very important submission. Obviously, we stand available to answer any further questions that may arise when the full committee meets to deliberate on this proposal, and we would certainly be more than happy to answer any questions, either orally or in writing, that you may have before you finalize your report to Parliament. So, but once again, thank you so much for this opportunity.
Thank you very much. Obviously, we will get in touch to you the time to time when there are issues of clarity that we might need. We will not assume in a presentation that is detailed like this. Thank you very much for your time once more again. Let me then go to our next guest speaker, and you are allowed to sit and listen to the others. If you've got time, if you wanna leave, you can leave. Thank you very much once more. Thanks, Mr. Nado, and thanks to you, Dan. Colleagues, we are doing very well in terms of time. I suggest that we go to our next speaker, Mr. Matomane Chidi, the Director of African Justice and Association, AJA. I like the abbreviation, AJA. He will be taking us, and again, we have received the presentation. It's with us. He will clarify to us this presentation, what he meant in his input, also that he wants this committee to consider taking up these matters further to the reports. Mr. Matome, hey, if I'm pronouncing it, I'm pronouncing in a Zulu way. You'll forgive me. Matome, who is over to you, sir. Please introduce your delegation, that you are with them in the platform, and how do you present in your 30 minutes your presentation. Over to you, sir.
Thank you, Chair of the session. For the record, my name is Matome. It's a Khelobedu name, far north of Limpopo. We are from the Africana Justice Association. It's written with K. Yes. And I'm alone. I don't think the other members of the association were aware that they could join me. Nevertheless, I will proceed. The association, of course, the presentation or the submissions were made by me as an individual. However, when the association became aware of the submissions and the proposal for the amendment, the association adopted the program, and that's why we are proceeding under the umbrella of the association. Of course, the association AJA seeks to advance human rights, land, and related reforms to contribute to thought leadership. And this is one program that we think is important for purpose of thought leadership, but also that if you want to have reforms, the law becomes the center of bringing about such reforms. So with those opening words, We are appreciative of the invitation, and we hope that with this platform, chair of the session and members available on this platform, that we'll be able to make our little contribution. Now, what do we want to achieve? What we want to achieve is a simple contribution in our view. If you go to Asia, the law that applies in China is their law. If you go to England, the law that applies there is their law. Europe, in the main, is their law. They have an influence of the common law from England, but for sure they are happy with it because they are all Europeans. So we are saying that the law that applies, or that should apply here in this country, should be an African law. And because the challenges that we have in this country, and the reason why we have the common law as the challenge, and you would note that we seek to have reviewed section 173 of the Constitution, right, with section 211 subsection 3 of the Constitution. At the center of section 173, which is problematic to us, is the dedication for the development of the common law, absent African law. So already we've got this law that was developed for a period exceeding more than 300 years. Now, still, when that law, we call it settled law, when that law is fully developed, you still want to further invest the resources of the country in its development. So our take is that the problem started in 1652, and it's captured this very well by Justice Lamont in the Equality Code. If you go to pages 17 to 18 of our submissions, the main submissions, you will see how the judge records that, but he says in simple terms, which is what we know as well, that immigrants from Europe arrived in this country, they gained control of the country, they imposed their law on the country, and today is the common law. He says the common law is common to all of us. The recognized law of the country is their law, is not the African law. And in the process, they stumbled upon rights of others, Africans and others who were subject to oppression in this country, people from India and all of that, Chinese and all of that. And they seized control of the assets. And the main asset they seized control of was land. Because, I mean, without land, you can't have a country in the first place. So if you want to capture society, you've got to take their land. If you take their land, you are in charge of everything. So if you want to solve even the land reform program, you've got to go to an African solution for this African problem, and you're likely to get it right. Now, these immigrants, as Justice Lamont says, they are. He says, paragraph 5, page 18 of the main submissions. He says, ever since the first immigrants had arrived from Europe, they had no regard for the rights, social, political, economic, or otherwise, of other persons inhabiting the Republic. One of the rights we have is to apply our law as Africans. That right has been abused, and somebody has got to correct that. If you go to page 1 of our presentation, we start with the following, and I must record that. I am tempted to think that it should start with the truth being told. Sorry. That truth is, we should not perpetually pride ourselves in and with applying a foreigner's law. We should jam the brakes on the perpetuation of the capture. I'm a practicing attorney, and I appear in the magistrate court, high court, and the regional court. But it's a great sense of embarrassment that every day I've got to apply the law that is not my law, in a language that is not mine, in a culture that is not mine. The adversarial nature of litigation when you are in court, the culture of one being an opponent and the other being an enemy. It's not African. So we've got to leave that culture every day. And it's a great sense of embarrassment. And that's why, as Ajahn, we thought we could make this contribution. But how does it come about? It comes about because you would see pages 2 and 3 of the presentation that serves before you, Chair, that we are saying, and I'm not going to go through that, and we show the case law in the court, which records that and discusses that. In essence, civilized people were said to be Europeans. If you're an Indian, African, and others, you would not be regarded as a civilized person. And as a result of that, the law of the civilized person had to apply on the law of the one who's not civilized. We can call them barbarians, whatever. That's the history. And we show it on pages 2 and 3 of the presentation, and we reference the case law relevant in the circumstances. If I may, Chair, I can take you to paragraphs 4, 6, and 8, and I'm going to say the following. From a decided
What paragraph?
Paragraph 4. Let's start with that of the presentation.
Okay.
It's page 2. Native customs are not applicable to civilized people. Native customs are not applicable to civilized people. Paragraph 6 says, that's me now. African law was not applicable to civilized people. However, Chair, I may not, let me not ascribe that to myself, because I see I reference case law as well, case of Mukwena. It's on footnote number 7. What it simply means is that the law of Africans can apply to Europeans. I'm talking about history at the time when you had natives, at the time when you had Europeans. But of course, today, as we know, there are 2 racial groups. We're called black and others are called white. And the history of it is the native European language that was used at the time. So that history still applies today. African law doesn't apply to people who are not Africans. And yet we are in Africa. But the law from Europe applied to everyone in this country. I mean, I was just in a conversation with somebody who had some matter yesterday in court, and he said, no, I'm in court and we're busy. Matter involves a child, and the gentleman married the wife with the child. The child was born of somebody, and when they got married, part of what happens in lobola negotiations is that you disclose that I have a child as your potential wife, and you marry that woman with the child. That is African adoption. But if you go to court, you're going to be told it's not complete. It's not recognized by the law. But that is precisely because that very well established and something that is practiced by more than 50% of the African population, it's not recognized because the law that we practice in our courts, the law that we practice elsewhere, is not the African law. It doesn't respect African law. And yet, that happens under a constitutional democracy. If you go to paragraph 8, you can read that for yourself. But I'm saying, for its primitive status, African law would not apply to Europeans. Conversely, for its civil status, civil law binds all. It is common to all. It is common law. Chair of the session, I'm not going to take it further insofar as the history is concerned, but what I want to say, in essence, and you have the presentation with you. I simply wanted to drive a point and show that the African law, it's not applied, save in cases of marriages and few other cases. But in the main, once you're an LLB student, you study something that is foreign to you altogether, foreign to us altogether. And that has to change. I mean, we can't be children forever as Africans and learn from others all the time. I don't know, I know that it's not something that some may like, but you don't have to like the truth, just has got to be told, and we're going to have it told. I mean, how does it happen in our society, and African society, that you can have a bill in parliament that seeks to suggest that a woman can marry 2 men? It's not African. There may be other people who are doing it, but it's not African. It's not grounded in our values, and our values are offended. And that is something that applies now, because our law is tumbled upon left, right, and center, and there are even efforts, and you will even be blackmailed for making these views that African customs do not support such an orientation. Of course, we may be told that our law is repugnant with the law of the West, and of course that is something that is in the past, but it's applied even today. Now, if chair of the session, with that background, you go to section 173, you will then understand, and that's my view. I'm not saying you should understand it as such, but I suggest that you apply your mind to understanding it as such. You will notice that the section says the following. It says the 3 High Courts, Constitutional Court, Supreme Court of Appeal, as well as the High Court of South Africa, each has inherent power to protect and regulate their own process. I'm referring to the section in the Constitution. And it further says, has the inherent power to develop the common law. And this is what we have a problem with. I wish not to take much time on the section, because it should be as clear as a candle in darkness. You invest the judiciary, because this is about courts, the resources of the judiciary for the development of the common law. That is not what. If you look at the section, it seems to suggest that it's discretionary. It says may develop the common law. However, there's a commercial judgment of the Constitutional Court, which and I will send this to my brother, Mr. Khoi, because we've been communicating. I'll send this after the presentation. But that judgment, which you'll have after the presentation, shows that it's not really discretionary. To some degree, there is an obligation for the development of a common law. So you've got to develop it. Now, how do you develop it? And this is the question. Common law from Europe. If some guy from Europe wrote something about the law of contracts or the law of adoption, we're going to listen to that guy, and his thoughts become binding law because courts consider that position, think through it, and adopt it. But it's not grounded in our values. And that's why you would have this law of adoption problem as a way of example. That's why you will have this economic challenges. Economic challenges is because the European way of doing things, it's individualistic, it's money, it's capitalist, self-centered. It's about me. But in the African sense, it's we. You are a member of society, and the little you have, you share. And how you share, it has never been it's for free. No, there's a very great program in Zimbabwe, in rural areas, and it's a very interesting one. We should be adopting it in this country. But at the center of that program is that no one should be poor, and society must make efforts for everyone to have something on their table. So if you then take the knowledge from Europe and you seek to develop it as per section 173, many of our problems will never be resolved. I mean, the land question, for instance, natural resources access, for instance, your sand, water, and others. We've got problems because partly we have moved away from the African orientation, which is communal in nature. You use these resources jointly as society, and we take care of the assets jointly as society. So we are saying that the Constitution, to the extent that it only provides for inherent development of the common law, then there's a problem. The reason why they use the word inherent is because you don't need any help from anywhere else as the High Court to develop that law. If we've got to, for instance, relying or sticking to the law of adoption, you have to listen to an authority from Europe, and he says no. It must be processed by government in a specific way, and that is what should happen, and that then becomes the legislation. If you follow that, then the court may say, because that person says what he says, based on what he has learned from his society in Europe, then in that case, that is the adoption that is going to be kept by a High Court, Supreme Court, Constitutional Court in this country. So you don't need any other thing, save the source. The source may be the book, source may be an article that was written in 1816 or somewhere there, some old stuff. But if you want to prove that in the African sense, if you marry a woman and the woman comes with a wife, that is adoption when you accept to marry that woman with a child. That is, if you want to prove that that is adoption, then in that case, it has to be paid for. And there's not many Africans who can afford experts. So already you are saying that that process, that application of that principle must be subjected to a monetary process that is very expensive for the many. We are saying the inherent part, it's grounded in that it's easy to, in my view, and this is my understanding, possibly, it's not too difficult to ascertain a legal position from the common law. You may find it in case law, you may find it in books, you may find it because it was recorded. Then it says to us, and this is my view, if the problem is the recording of the African law, the recording of the African law can never be a problem. We write books. I'm one of those who write books. There are many who write books, write articles, and there are many who do that better than I do. And there are many who are grounded in specific aspects of African customs, traditional healing, traditional religion, family law in the African sense, conflict resolution in the African sense. There are many. Now, those people can help us reduce to writing many aspects of African law. There's many aspects of African law. If we were to focus on trying to reduce to writing, they will become recorded material on the basis of which, one, African law ought to be applied, no longer subjected to legislation, because at this stage you can only apply African law if there's legislation regulating it. No, you follow the thinking of the development of the common law, that I'm going to rely on any source that I find, including work recorded by Africans, which shows how this African law should be understood in society. Of course, there may be a different understanding of African law from different communities. If you go to Watoka, for instance, if you go to Khelobedu, if you go to other tribal groups, other Africans, they would understand different issues differently, but there is usually a common denominator with exceptions. So all those would be recorded, but at some stage, as you develop African law, you are likely to have some sense of unity. So that's my take insofar as section 173 is concerned. If you go to section 2113, you would see, you would see how we think this should be amended. If you go to page 3 of our main submissions, I'm not going to discuss much because I'm a bit out of time, or I'm about to be out of time. On page 3 of the submissions, we show how it should be it should be amended. But in essence, what we are saying is that there should be a commission established for the purpose of encoding into writing African law. And when we do so, though as we propose, of course, there may be other proposals as we go on if the committee deems it proper for this work to be processed further by the committee, and we can still engage as we go on the actual wording of the amendments. If you go also to section 173, we are saying the following. After we are saying it's I think it's page 2 of the main submissions, not this presentation, the main submission. I see we have flighted the presentation. Perhaps you're looking for the submission. It's page 2. Yeah, but in the meantime, let me proceed and indicate what we think should be the amendment. We are saying the following. The courts have
the presentation. Is it you or is Pilot?
Yeah, no, here it is the submission. Yeah, here it is. If you can go to page 2, that's page, this one. And the highlighted portions, the italicized, highlighted, it reads the African law and/or, that is the addition, and then it says and/or the common law, and it says and in respect of the common law only if necessary. So what we're saying is develop the common law only if necessary, but the first law to be developed is African law. We are in Africa here, we must focus on the African law and have pride in our own law. I mean, it's our heritage after all. Where else can we enjoy our heritage other than in Africa? Then we propose an addition. It's as 173, capital letter A. One of that says the development of common law shall be attended to only if in the circumstance of a particular case, African law may not be developed. 2, the developed law in accordance with sections 173, the current one, and 173A1, which I've just read, shall be binding on all persons, regardless of their racial group and or any other consideration. So what we're saying is this notion that African law cannot apply to people who settled in this country and continue to come and settle in the country. That notion should be done away with. I mean, if they can have their law applied to us, why can't we? I mean, there's our country, and that is the understanding of the Africana Justice Association. Chair of the session, let me pause here and simply indicate that what we seek to achieve, and we can read the presentation as well as the submission for your deliberations, and we are available for further engagement because I see other members of the community are not here. What we are saying, in essence, is that at some stage, if we are really going to transform society, we need to turn to the law, because it is the law which governs sports, it's the law which governs these proceedings, it's the law which governs telecommunication, it governs all facets of life. So if the law that we have is not grounded in African values, and which are, by the way, very accommodative, if the law is not grounded in African values, then we should forget about our heritage. We may speak English, a lot of it, which is not our language, may read a lot of books, but in the end, we are going to be judged wrongly, that we fail to do what ought to have been done. African solutions for African problems. It's not a political statement, it's a very legal statement. Thank you, Chair of the session.
Thank you very much, but there is a very thin line between political statement and your conclusion part. Thanks. Thank you very much, Mr. Matome Chidi, on your presentation.
Thank you, Chair.
Members, you have listened to a very interesting debate presentation. And let me put it to you for comment, clarity, seeking question. Pilot, you will assist me should any member raise his hands on the platform? You see one, Pilot?
No, Chairperson, but we've been joined by Mr. Okamp. Mr. Philip Okamp is in the platform. Honorable Mr. Malek.
Okay. Mr. Okamp, would you have any comment on the presentation? No. No, thanks once more again. Is it correct to say Advocate Matome?
No, Mr. I'm not an advocate.
Mr.
Yeah.
Oh, Mr. Matome. Thank you very much for this presentation. It really is quite interesting to all of us. We will definitely look at this section 173 with the sub-clauses that we have referred to us. But to me, I've got one question as to, in South Africa, it's got so many languages that we are speaking. And we come from different tribes. How would you foreseeing doing this African Law Commission? How it be structured?
No, thanks, Chair. The question of languages to start with, most of them don't differ much. If you listen to people talking, most of words are similar. Of course, in some instances they mean different things.
Yeah.
But that is the language part. How do you foresee the commission function? In this presentation, I spoke about the principle of sharing, communal use of land. It's something that applies everywhere. So, called different names by different people. But if the commission indeed operates, it may guide the country on how, for instance, communal use of resources may be utilized, or how it's understood in the general African community. If there are exceptions in, say, for instance, vendor customs, those will be recorded. But I said at some stages, you record them, you subject them to the Constitution for them to pass muster. And at some stage, you will have a sense of uniformity. That's number one. Number two, I gave an example of the law of adoption. The adoption principle applies in all communities. You simply record it, but seek to understand how different communities do it. So what you could do, if you come to Limpopo, you can come to me on a specific principle, because I can't know everything. For instance, just as an example. But in Limpopo, I wouldn't represent all tribal groups. There will be people from other tribal groups. So they come together in the way that the Constitution was drafted. They come together and each one contributes as to how their society observes that principle of adoption as an example. And in the end, the group that comes together for that purpose produce a manual that says this is how this principle is applied, perhaps in different tribal groups in Limpopo and in other parts of the country. And we seek to identify common features. And those common features are then recorded as the law. Where there are exceptions, you show that this particular group agrees with the main principle, but these are the exceptions. So there would be a sense of uniformity, because if a dispute arises in Johannesburg and it involves people from that particular tribal group, that recording will be applied. This is how we should resolve this dispute in Johannesburg of people who are from, for instance, CASAC, the former CASAC, if you like, or vendor. So that would be how basically you have it applied. That's my take, Chair, if my answer assists. But in my view, efforts ought to be made. It would be difficult. It was difficult to develop the common law. It was not easy. But I think with the African law, still it will be difficult, but resources can be devoted for that purpose. I mean, we have the South African Law Reform Commission in Parliament as we speak. It's not dedicated to the development of the customary law. If they can do it with that commission, which sits in or which is part of Parliament, I don't see how we can fail to do it with the African law. The only thing you need to do is that if you were to bring people who are more than 40 years experience in law, they are likely to be very happy with the law they know, and they are likely not to really contribute much. So you need a blending of young people as well as those who will work together to try to achieve that. Yeah, but it will require people from all parts of the country to contribute if we were to do it.
If you were to be asked to put this in systematically, to say, how would you draw an organogram of this proposal? I'm looking at, you've got your tribal groups, which you can do in Bezos and everything else. You've got those that are writing as well, like yourself, for language purposes. You also got legislation. In terms of the structure, where must we start to approach this Section 173? If you may structure that, if we can start here and come here and go there, and finally result that will give us this African law, or that common law that we will understand all of us, and then strive to balance. How could you assist me so that I also understand this proposal quite clearly with the notes that you've given us?
Thanks, Chair. First of all, for the commission to be resourced, there should be legislation that governs the functioning of that commission. So the amendment in the Constitution would say there must be this legislation, but then the Chair's question is, how would you structure the commission and how would it function? The preliminary view I have at this stage, I have not really applied my mind much to that, but yeah, to some degree I have, is that you would have a person who chairs the commission. You have other executive members of the commission. They may be commissioners, managers, whatever language will be proper. And they then should be different subjects focused on. If we think, for instance, that it's important to prioritize the law of adoption, as I spoke about, then there is a research team in the commission which works with people from outside the commission and invite submissions from members of the community, and they process these proposals. But in the end, African law, it's best known not by we, the people who claim to be educated. It's known mostly by elders in your communities. So there should be an interventionist program in terms of which you are able to consult even those you think are not educated, but they've got that wisdom which you need, and they guide you on how to develop that principle. And once the research unit is satisfied, then there should be a process to bring to finality the study. And that product, a chapter in your African law reform, that product then would be what we call the law, say, for instance, of adoption. It may be the law of contract. There are many agreements with each, but when you check what the requirements of common law, They don't reach them, but yet there are agreements. So an agreement on exchange of cattle and pigs and goats, a trade of some sort which is practiced. It might as well be necessary to invest your time in that and say, perhaps this is important. Let's see how these agreements are structured. And because they are agreements, but they are not enforceable in your court of law because they don't comply with the common law principles. How should they be understood? And a chapter, further, given that structure of researchers and people outside, a chapter is produced. And what you can also do, and of course we struggle to do it, lawyers don't seem to be interested in this type of work, but perhaps when there's a national effort to build a body of knowledge that is African and have it reduced into writing, they may be interested. You might as well approach them. You might as well, chair the session, use the resource we rarely use. Retired judges, they've got a lot of wisdom. You can learn a lot from them. Of course, they may have accepted the common law as the law that should apply, but once confronted with something of this nature, they may go back to what they know, who are knowing, and of course assist to the extent they can. So that is the structure. So we may have judges, we may have researchers, we may have commissioners, you may have people of specific communities assisting in that process. Obviously, somebody has to facilitate them because you can't consult the whole country, but they may be that process. And a voluntary program, I mean, if you approach your BLA and others, they may likely be able to volunteer their services, simply to record what they are taught by elders who are unable to write, simply to record that, process it in the way they understand it, and at some stage bring to the attention of the researchers such produce knowledge. And in the end, we have chapters of different subjects. Thank you, Chair.
Thank you very much, Mr. Matoma.
Thank you.
With the input that you have given us, it will really assist us in also crafting the report, but I foresee a lot of engagement with your office in trying to clarify some of the issues that you have made, like one of the example, a few examples you have given us that you think your argument comes derived from those issues under Section 173. It's really appreciated. But just one more clarity before I go to the next presenter. What is it that stops you now? Because do you only want the legislation part just to acknowledge this process? What exactly is your proposal? Is the acknowledgement by the legislator your issue so that it can be discussed going to forming the structures like your commission, your communities, your researchers? What exactly do you want us to do? If you may summarize in 2 words.
One,
under this section.
Oh, sorry, Chair.
I'm saying under this Section 173.
Yes. No, one, that it be amended as proposed. 2, that amendment specifying the establishment of the commission. Okay. The time within which it should be established would lead to the actual establishment, the legislation, and later on the establishment of the commission.
I understand.
Yeah, if that assists, Chair.
You know, it does. It does. Members and colleagues, here are is any other hands, pilot, that you see? Any further clarity?
No, Chairperson, I don't see any hands at the moment.
In that case, let me thank your presentation. As I've said that many times, Mr. Matoma, it is really, we are going to look into it. We will present it to the other members as well. There are recordings in this meeting. We will listen to it over and over again. and then crafting our reports. But where we need your intervention, we will definitely come back to you and do that. Thank you very much, sir, once more again. You may leave the platform if you've got other engagement, or if you are interested in the other next presentation, you are free also to remain in the platform and listen to the other inputs as well. That would
Thank
be
you, Chair. Thank you, Chair.
Thank you so much. Colleagues, we are now left with one presentation. In terms of my program here, the last presentation will be presented by NPC. The presenter would be Kutso Selowa, the director of Valodagoma NPC. Valodagoma. You will correct me if I pronounce it correctly as well. This organization. It is over to you, Kutso, to take us through your presentation. Members, we do have this presentation as well. I think it will be flighted on the screen.
Chairperson, I think I don't see Kutso on the platform, but we do have.
I am here. Sorry.
Oh, okay.
Yes,
Okay.
I am. Thank you very much, Chair. Good morning to the sitting. My name is Kujo Sulowa, as already said, the founding director of Valodagoma NPC, nonprofit company. I have with me my colleagues, Dr. George Mahashe, who is a senior lecturer based at the Michaelis School of Fine Art at the University of Cape Town. I also have with me Dr. Debo Rahoho, who is a lecturer and head of department in the Department of Applied Languages at the University of Tshwane University of Technology. And then I also have with me Mr. Kotazo Sishai. He's the co-creator of Khelobedu orthography. He is the compiler of the Khelobedu dictionary as well, and also the core translator of the Khelobedu Bible with the Bible Society of South Africa. I don't know if I have sharing rights. There's a slide presentation that we put together, particularly for this sitting.
Yes.
Chairperson, let me find out who is going to flight it. I did not receive the PowerPoint, so perhaps they can assist so that I can give the presenter the co-hosting rights for them to flight it for us.
Okay. Kutso, are you there?
Yes, I am still here. I am unable to share. It says host disabled participant screen sharing.
Okay, try again, Mr. Slow.
Okay. Oh yeah, I think we should be good to go now. Can you all see my screen?
Yeah, I do see something now.
Okay. Yes. So we made a submission in 2020, I believe it was April, and it was called to have Khelobedu recognized as an official language and included in the mandate to develop the Khoi and the San languages and sign language that have been mandated in Act 10 of 1999 of the Constitution of the Republic of South Africa. This presentation is made by Valodagoma NPC. As I said, my colleagues will be jumping in every now and then and will be covering certain slides in this presentation. There will be quite some fluidity as well, where they can add points and also try to give a bit more understanding. Now, the first slide being the historical background and context, maybe just to confirm, can you guys see the writing on the screen? Is it big enough?
But it's very faint.
Okay, let's see if I can't
size 8.
bring it forward a bit.
At least 10.
Is it better?
Try 10. Let's see 10.
I'll also make sure to read it out and make sure everybody can hear what was there. But just to start, so Khelobedu, with the brief history, at some point in their history, they did have contact with people presently known as Bavenda and also Northeastern Sotho people. And although Khelobedu as a language, or rather, Khelobedu as a language still has distinct grammatical features, which suggest that Khelobedu is an independent language. So up until when the apartheid government took power in the 1940s, the indigenous languages were being developed by missionaries. The apartheid government demoted Mujaji, that is the queen of Khelobedu, from being a queen to being a chief, along with their language and subsequently culture being demoted as well. Although the government has since restored Mujaji's title of queenship, the language is still subjected to dialect status. So despite Khelobedu being an independent language, Khelobedu learners still have to do Sepedi as a mother tongue language at school. The word mother tongue in this context is a misnomer to Khelobedu because the language they speak at home is not the same as the language they are required to do as a home language at school. Instead of solving the problem by letting Khelobedu learners and teachers work with Khelobedu as their home language, programs are being developed that force teachers to help their learners first comprehend Sepedi before teaching them in that language. Instead of developing the Khelobedu language and allowing both teachers who are also Khelobedu and learners to continue interacting in their mother tongue, which is Khelobedu. So in this context, Khelobedu have not been able to get a useful oral tradition because they do not have access to the language in its entirety due to their language being Sothoized. And for this context as well, I will open up to my colleagues so that if they do want to add some points here, they can very much do so.
Yes.
If no comments, then I'll go to the next slide. And then, is it not scrolling? Okay, scroll here. And then hand over to Kotatsu.
Morning, Chair, colleagues, and the rest of the committee. I'll be going through the development and testing of the Khelobedu orthography. One of the challenges in the past was that Khelobedu did not have an orthography, as well as literature and educational material that can be used to develop the language in a written form. So to address this hurdle, the Khelobedu took it upon themselves to start with the development of the orthography and also produce other material that can be used to standardize the language and reduce it to a written form. Due to the similarities between Khelobedu language and Venda, an orthography akin to Venda was developed because even on listening, one can hear that Khelobedu in itself, it's an amalgamation of Karanga, Ngona, and Sotho. And to this day, the statement made by the Kriches in 1943 stating that it approximates to Venda in much of its vocabulary, falls midway between Sotho and Venda in grammatical structure, but Sothoized in phonology, but many of its sounds are unknown in Sotho. And it is for this reason that an orthography akin to Venda was adopted. Also, a developmental dictionary was made available to the public for review, as well as to initiate the process of a possible standardization of the orthography. And this gained the attention of the Bible Society of South Africa, seeing the willingness of Khelobedu, as well as the feasibility of the translation process for a Khelobedu Bible. And they greenlit the project and made a committee consisting of about 15 individuals speaking for different varieties of Khelobedu, that is Kekwebo, spoken by the Royal Compound and surrounding areas, and Kitswabo, Keroga, and the Mamaila variety. The inclusion of these different varieties ensures that not only one variety is used in the written language, which will result in formation of a superiority complex, as well as marginalization and stigmatization of the varieties which will not be included in the written form. It also benefits the language as it expands and enriches the written form with a vast number of vocabulary as utilized by the different groups. The inclusion of the young and the elderly people also is beneficial, especially when elderlies are included in the group. They still retain some memory of the proper usage of words as well as proper pronunciation. That is becoming more and more faint to the younger generation. And there is emergence of vocabulary that has since been displaced by the Northern Sotho vocabulary that we use at school. For example, words like madrenko for evening is displaced by manjivoya, which is derived from manjivoya of Bidi at school. And words like makai for lice is now displaced by maga that we use at school. And words like le fomi for 10 is replaced by the Northern Sotho lesumi. So in all this process, it becomes more apparent that Khelobedu as a language, though it might have roots in both Sotho and Venda, it still has some autonomy. And when pushed as a dialect of either of the two, it is compromised and it puts Balobedu at a disadvantage. And it is because of this reason we believe as Balobedu that it should be accorded the status of a stand-alone language, because if as a dialect of Northern Sotho, some features of Khelobedu cannot be utilized for educational purposes. And if regarded as a dialect of Venda, more features which Balobedu do not recognize and are foreign to them will be introduced to the language. That's not solving the problem at all. Thank you. I'll hand over to my colleagues if they have something else to add.
Yes.
I think it's well put.
Okay, thank you.
Kotato, you can just finish up on the second slide here.
Okay. Chairperson, through you, Dr. Mutsefa is on the platform, maybe just to recognize him.
So the extensive and rigorous process used in the translation process not only challenges the vocabulary, it also challenges the grammatical features that will be used to standardize the language. And it's very beneficial because in doing so, even the orthography itself begins to evolve into a more practical and readable vocabulary, but also not compromising the linguistic and phonetical structure of the language. And with regard to Northern Sotho, Khelobedu grammar leans more towards it than Venda, but much of its vocabulary still is similar to Chivenda, thus creating a dilemma that needs a resolution that will not put Khelobedu at a disadvantage and not sacrifice the integrity of the language. And as I've mentioned before, that is the main point that we're driving home, that not only to restore the integrity of Balobedu, but to resolve this dilemma that Khelobedu has, it should be accorded its status of a standalone language. I think that is the end of my slide.
Yes, I'll now hand over to Dr. Mahashi. Or rather, sorry, I'll go through this one myself, and then the next one will be Dr. Mahashi. So in preparing this, we also did look through a few articles, published articles in journals about the struggles that Khelobedu learners have when they're doing Sepedi. And one article was picked out in particular, which is a study titled Exploring Grade 8 Khelobedu Speaking Learners Writing Challenges in Sepedi Home Language in Mopani District, South Africa, which is where majority of Balobedu are. So according to CAPS, which guides the teaching and learning in South African public schools, the home languages offered at schools in Mopani District are Sepedi and Xitsonga, according to the Department of Education. Therefore, learners who are raised in Khelobedu communities who speak Khelobedu at home and socially are compelled to learn Sepedi as their home language in schools. Despite Khelobedu being an independent language, Khelobedu learners still have to do Sepedi as a mother tongue language. This is where that whole misnomer comes in, because that is not their mother tongue. And then in 2015, the learner performances in Sepedi was reported at 53.71% pass rate in the Greater Zanin municipality, where Maputo circuit is located. The learners' performances are recorded as being 14.59% less than the national average, posing a serious concern in the district. According to basic education requirements, for one to proceed to the next grade, they need to have passed their home language. And Balobedu are already put in a disadvantage in that regard, because it is not their home language. And when they do struggle, they are then not permitted to go to the next class. And then the study goes on to say that it is evident from the data presented in the study that the grade 8 learners who were chosen as a sample for the study were struggling to write in Sepedi because it is not their L1 or home language. Learners spell as they speak. They have limited vocabulary in Sepedi and consequently end up using Khelobedu words in Sepedi writing. As a result, their spoken language appears to interfere with their writing instead of being additive. This supports Crow, Berry, and Van's 1981 conclusion that the writing of all learners closely resembles talk written down, which is likely to incorporate many features of speech, including speech sounds of their language. All these experiences are contrary to the behavior theory, where learning will occur more frequently when followed by reinforcement, imitation, and association under controlled conditions, as pointed out by Skinner. Also, I will open it to my colleagues if they have anything to add on the slide.
No,
If not, we can go to the next slide and I will hand over to Dr. Mahashi.
Thobela. For my presentation section, I think I want to pick up on an issue raised as point 17 of the legal judgment that was sought after our submission. For me, the issue of Khelobedu as a marginalized language, whether as a marginal subsection of Sepedi or just as an indigenous knowledge in the South African language family, is more than anything a result of a punitive act by the apartheid government, because Queen Mujaji was quite active in bringing coherence to the northeastern Transvaal at that point as resistance against apartheid. So when they demoted her to a chief, that had more to do with trying to break Balobedu's coherence. And as a result, the language followed. As a result, they blocked the development of the language by missionaries and promoted Sepedi much more aggressively in the region. So Khelobedu's position and its current Sothoization is the result of that moment. For me, Kuthatso has given a context of how Sepedi becomes, how Khelobedu becomes what it is in relation to Sepedi. A point that I would like to also add is that prior to the 1930s, when anthropologists decided that Balobedu would be absorbed by Bapedi, Khelobedu had its own diction that has subsequently, over the last 90 years, been completely pushed down into the underground. So for me, I think that's the most important context to put. With the recognition and the restoration of the Balobedu Royal House, there was an expectation, or rather, there was a moment of unity that Balobedu have now received, because all of a sudden we are visible. An important thing to note in relation to what Khutjo has just put down about the learners. Khelobedu is a matter of pride. Up until maybe 2017, when I was at Wits, Valodagoma hide. They do not speak their language in public. They pretend to be Bapedi, and this is very common. So there is an issue of shame around being Khelobedu. We are constantly told that we are not South African. So there is an issue there of woundedness that is associated with the Khelobedu language as something that does not exist. So there is an issue of Khelobedu not being seen as part of the South African franchise. There is a perception by other groups that see us not as South African, and that's a serious problem. So even if one could address the issues the learners are facing through technical means of providing more material, the issue is not whether the students will pass, is whether the students will be confident enough to use their knowledge and background to contribute to South Africa. An important aspect of Khelobedu is that we come with the history of many, many years of observing South Africa's ecology. And we have a lot to offer in terms of our knowledge of the ecology, our knowledge of drought, our knowledge of ways of managing water resources, and all of that knowledge is locked in our language. If we do not give dignity and pride to Khelobedu, that knowledge will remain hidden because we will never bring it onto the table. So for me, it's an important point to raise that making Khelobedu official is about restoring our sense of being part of the nation, even though it is not necessarily even though it's discretionary. The important part is that the act of making it official is a way of undoing more than 80 years of apartheid era punishment to Khelobedu. So that for me, I think is a very important part, the aspect of reassuring Khelobedu that we matter, that we are part of the country. Like the Khoi and San, we are a group that has been systematically, structurally excluded from the franchise of South Africa. It is important to address that issue by the gesture of making Khelobedu official. So I think for me, that's the most important point to raise about why Khelobedu should become official. And also it's important to note that even if you put money through institutions like PenSouth to develop the language cannot develop until Khelobedu buy into it. Khelobedu will buy into it when there is a sense of national pride. In order for PenSouth to do its job, Khelobedu have to write, have to publish, have to create the material that allows development. As long as our students value Sepedi, they will always produce material in Sepedi. So I think for me, that's important. So any of the developmental mandates are not feasible unless the pride of Khelobedu is restored. And then one point, the other point to add, we are in the process of finalizing the rights to publish the completed books of the Bible, which test out the orthography that's being developed. And with that, there is a potential for us to at least put out more Khelobedu material out there. And I think Khutjo can just share an image of what one of these chapters look like. At the same time, as a researcher during the year of meeting 4 times a year for 5 days straight, I have been recording the discussions, the debates, the processes of coming up with languages where one can see that a lot of the Khelobedu vocabulary does not exist in Kisutu. And there is an opportunity for us to use the artificial intelligence to be able to take that type of material and assist our generation in making Khelobedu more accessible on the internet. To say that the 4 IRs, I am referring to a program at UP where they are teaching computers how to translate English text, any other text into Southern African languages, and there's a moment and an interest in languages that have low resources. And to say a language has low resources, it means there's not enough that has been written about the language. So we also sit at a moment where technology can assist in bridging the gap that is created by 8 years of not developing, of not producing sufficient quantities of Khelobedu material. And maybe let me stop there, Galebo.
Thank you very much. And then for the next slide, I will then go to Dr. Rakhoho to take us through it.
Can you share with us that material first, Khutso, before we go to him?
The chapter, the Bible chapters.
Yeah, that he said you can share with us here so that we.
I'd have to
Okay,
open up
okay,
the program.
Let me not disturb. Go your own way. Khutso is fine. I thought it's something very close so that we link with this presentation easily. Okay.
Yeah, we will share it along with the resources. We're going to share more resources because it's a development process. We just received those rights to go ahead and share it with the public. So it's some of the resources we will be sending to you guys.
Thanks, Khutso. Go ahead.
All right. Thank you, Chair. Good morning, colleagues. Yeah, my name is Teboko. Maybe before I can talk to the constitutional imperatives, I think in the historical background, Khutso, especially on second bullet point, touched on the issue of missionaries. I think for the purpose of this presentation, it may be important for the committee to understand the partnership between the missionaries and the colonial government. So if we were to look into the historiographic analysis of the partnership between the missionaries and the colonial government, critics may support that this is considered, or this should be considered as one of the contributing factors or the qualitative variables that gave birth to the stigmatization of Khelobedu as a South African indigenous language. And it is also important to mention that in the 19th century, the standardization of the so-called Bantu languages, especially in a South African context, was handled by missionaries. So in the case of the language under attention, which is Khelobedu, so the history articulates that in 1860, Alexander Merinsky from the German missionaries was responsible for the standardization of the Sepedi language. So through the partnership between the missionaries and the colonial government, the decision was taken that Sepedi as a dialect should be elevated to the status of an official language, and the rest of the languages like Khelobedu were classified as a dialect of the Sepedi language. And you may realize that should be considered a colonial casualty, because that decision lacked a linguistic justification. People were not consulted. There was not even the process was not even transparent. So the decision to classify Khelobedu as a dialect, that decision, Chair, only accommodated the administrative system of the previous regime. So let me go straight to the constitutional imperatives. There's a link or connection between section 6.1 of the Constitution and also Section 7.18 of the Constitution. Obviously, Section 6.1 talks about the status of official languages in the country. But when you go to Section 17.18 of the Constitution, it talks about the freedom of association. So in terms of this presentation, this particular section takes us to the issue of the relationship between language, culture, and identity, which cannot be separated, meaning that we as Balobedu cannot be Balobedu and Bapedi at the same time. And then when you go to Section 5, Section 6.5 of the Constitution, it talks about the role and the responsibility of the Pan-South African Language Board, established by national legislation, that PanSALB should promote and ensure respect for all languages commonly used by communities in the country. So from a constitutional implementation point of view, Chair, you may realize that, I mean, the Constitution went further to list some of the European languages that we don't even know in the country. But languages such as Khelobedu were not even listed. And if you can go and check the statistics, you may find out that the numbers of the Khelobedu speakers in the country are even more than the number of some of the languages that were accorded the official status in terms of the Section 6.1 of the Constitution. And we have already indicated that the decision to classify Khelobedu as a dialect lacked transparency, consultation, and a linguistic justification. And from that view, Chair, you will realize that this becomes a social justice issue. Not only a social justice issue, it also becomes a linguistic human rights issue, because our linguistic rights as Balobedu were undermined because we were simply categorized and classified as a group of Bapedi without taking into consideration the linguistic justifications. You go and check Section 2 of the Traditional Leadership and Governance Framework Act 41 of 2003, Chair. It talks about the official kinships and queenships in South Africa. And from that table, you realize the Balobedu is the only official queenship in the country. We have Amaxhosa kinship, and they do have the language that is attached to their kinship. AmaZulu kinship, there's a language that is attached to their kinship. There's Vavenda kinship, there's a language that is attached to their kinship. Amandebele kinship, there's a language that is attached to their kinship. The Bapedi kinship, they also have their language, which is Sepedi, that is attached to their kinship. But in the context of Balobedu, we have got a queenship, but there is no language, there's no official language that is attached to the queenship. And to recognize the queenship in terms of this piece of legislation is to recognize that these people have got their own identity, they've got their own culture, they also have their own language. So in conclusion, I think it is safe to indicate that, especially in terms of this presentation, Chair, in a South African context, decisions about whether speech forms constitute an independent language or a dialect are in most cases based on language ideology, not necessarily on linguistic criteria. And this is particularly because language planning in South Africa is actually a political exercise. And this is the reason, this is one of the contributing factors why Khelobedu as a language was sacrificed. And it is also important to mention that it was wrong to classify Khelobedu as a dialect of Sepedi. Khelobedu is not a dialect of Sepedi. And those who are advocating that Khelobedu should be treated as a dialect do not want to take into consideration the historical reasons and how languages were standardized and how languages were accorded the official status internationally. So I think the struggle of revitalizing and recognizing Khelobedu as a South African indigenous language in terms of this presentation is a postulation for epistemic justice as a core imperative of decoloniality. I've already indicated that the decision to classify Khelobedu as a dialect, it undermines our linguistic rights as Valodagoma. So it is a linguistic human right. It is also a social justice matter. So in conclusion, Chair, Khelobedu as a language has got its own linguistic repertoires to serve as a fully fledged language. And from this presentation, I mean, the good stories about the translation of the Bible, the dictionary that has been prepared, is a clear indication that this language has got its own linguistic repertoires to serve as a fully fledged language, not to be treated as a dialect of another language. Thank you, Chair.
Thank you very much, Chair. The resource that Dr. Mahashe was alluding to, being Genesis chapter, is here on the screen, and I will allow Khothazo to just read a few chapters just so we can see how Khelobedu is and how it actually sounds. Khothazo, you can go ahead.
Please.
Okay. Genesi ya bili utholwa alifasi. Mathomo ni modimo thode mathado le lefase. Lefase le be le khena ke bobeo le ona le khena khelo. Bodiba ba o thiba zothe bo be bo aparetegi le tshwifi. Moya wa modimo o alamete mazi. Modimo a re a o be le khiedi, khiedi ka ba ona. Modimo a bona khiedi khena khile, a khobantsha khiedi le tshwifi. Ke mo ga modimo a re khiedi ke matsheare le tshwifi a re ke bosiu. Wa fera madrenkgo wa da mutsho leo e be ile jaji la mathomo. Modimo a re a o be le lefaufau la o khobantsha mazi a be mafilone a mabedi zwa diea. Ke yona modimo a khidia lefaufau a khobantsha mazi a ka fase ya lona le a ka dedulu wa lona. A re lefaufau ke le rata dima wa fera madrenkgo wa da mutsho leo e be ile jaji la bobedi. Modimo a re nge mazi a ka fase ya leratadima a khobagane felo ka uthi gore fase mo o omile o bonale zwa diea. A re mo o omile ke leshago mazi a khobagane felo ka uthi a re ke lewate. Modimo a bona zwinakhile. Ke mboka a laela a re nge leshago le gweleje zemela o ya ka mefuta ya zona zwa o fara dithoro le mere ya wanwa metšhelo zwa diea. Leshago la gweleja zemela o ya ka mefuta ya zona Modimo a bona zwinakhile. Wa fera madrenkgo wa da mutsho leo e be ile jaji la boraro. Modimo a re nge o be le zwiedi ratadimeni o khobantsha matsheare le bosiu zwe be zwe ka za o subeja o thoma amajaji le memyaa le khathizo zibileo ziphadime le ratadimeni o bonekela lefase zwa diea. Ke wona modimo a khidia zwiedi zwe zibedi zwe zolo le jaji la o busa matsheare le miedi wa o busa bosiu le lenanedi.
Thank you very much, Khothazo. Chair, that was just to give you a bit of a hint of the work that as Valodagoma we are doing with the Bible Society of South Africa and along with the royal houses of Khelobedu and the elders as mentioned before, and how much work is actually being put out for Khelobedu. So that brings us to the end of our presentation. We thank you very much again for giving us this opportunity, and we hope that our call and our cry will be heard by this committee. Thank you very much.
Thank you very much, Modimo Akada Zwera Zwi, Zwavadi Zwe, Zuhari, Lejaji Huvusa, Macheha. You see, we need to learn this African language. Thank you very much for the reading. It was quite interesting. Members, here is the presentation presented to us. Let's engage with it. Thank you very much once more for the material. You know, if you will ask me to read it, I will read it in Zulu. And it's true that some of the words, you know, they're very similar, even though they are written in different languages. I now know why you want Khelobedu to have his own standing. Members, there's the presentation in front of us. Can we start to engage with? Let me also recognize the doctor, my co-chair in the platform. I'm told he is already locked in. He was also engaged in another executive meeting earlier on this morning. Thanks, Doc, for joining us. Are you there, Doc?
Thank you, Co-Chair, for steering the ship so well, and thank you for allowing me to attend the other meeting.
Yes, let me start with you, Doc. If you have a seeking clarity question on this presentation, because this one you had it, I know you were here.
No, Co-Chair, the clarity is just from the submitters, whether they believe that the question of orthography is finally settled, and all that is required is really to proceed with question of literature, so that, you know, at the moment we have early childhood development centers that are being mainstreamed, whether they think they can be ready even to produce literature for use in the ECDs. That's all.
Any other question, members? Otherwise, Kuto, you may respond with your team.
Yes, thank you for that. We believe, because of the work we've been doing, and not only because of that, but also of the archived work we've been able to get about the orthography of Khelobedu, we believe the orthography question has been answered. And we believe that especially the work we are doing with the Bible Society, that can give solid ground for more literature to come out, especially if that is the most tested orthography in Khelobedu, the most agreed upon, and we can continue forward with that. And the rest of the questions I can also open up to my colleagues to have a go at it.
If I can come in, I think indeed the orthography question is settled, and it's just a matter of time for things to be streamlined to a point that everybody can easily buy into it. The point that remains to be hammered down is that in order for more literature to be produced, sense of pride about Khelobedu needs to be heightened. So it is really that the two go hand in hand. We can have the orthography, but without that sense of pride, not enough material will be produced. But for the purposes that Prof. Motseka has stated, we are ready to meet those demands.
Okay. Also, my question is that if you may assist me, you know, in the Nguni language, like Swazi, Xhosa, Zulu, they quite close to each other. Even some of the spellings are the same. How different it is, Pedi and Khelobedu? Is in the pronunciation of the words, or it's totally when I'm trying to think here, I knew the political issues, how the Khelobedu was undermined, but I just want the language, how closer it is to each other.
Thank you, Chair. And Khutazo being more technical in this regard than I am, I will give it to him to have a go.
Okay, thank you. To answer that in a simple answer, so Khelobedu not only possesses a higher degree of vocabulary that is similar to that of Venda because of the interaction of the early Balobedu with the Ngona. Also, it carried over some of the grammar that is akin to that of Venda. So when it comes to Khelobedu and Pedi, so the main people that, or the main Sotho people that Balobedu interacted with, they were speaking Northeastern Sotho, which possessed much more primitive sounds or much more primitive features as stated by the missionaries. So that is how it will be different. While Pedi is much more advanced in its phonetic structure and also possesses a higher degree of the mainstream Sotho vocabulary. Khelobedu, on the other hand, it has primitive structure of Sotho as an umbrella of languages, and also it has a high degree of vocabulary that it carried over from the Ngona language of Bavenda, and also some vocabulary that is actually from Karanga, so it will make it more similar to Shona languages, especially your Eastern Shona languages. That is how it differs. So it will have grammatical features which are similar to Sotho because of the interaction between Khelobedu and Northeastern Sotho. But even in that regard, for instance, so though the baseline phonological process might be the same, you end up with, for instance, a word for child in Sepedi is ngwana, and then in Lobedu is miana. These two words are cognates, but because of the different phonological process which are applied in these two languages, you end up having two words which are similar but still different. For if I said Nyana to a Pedi person, somebody who has not done linguistics will not understand what I'm referring to, but only a person who has a linguistic background will then be able to determine that Nyana is actually Mwana in Pedi. And that applies to several other words.
Chairperson.
Yes,
Chairperson.
Yes.
Can I just do a follow-up? I want to know if the submitters have investigated into the fact that Khelobedu is actually Khilozi, which was an official language of the Empire of Vulozi, which covered a great Zimbabwe, southern Mozambique, eastern Botswana, and northern province. In other words, I'm trying to say that talking about linkages with Venda, Pedi, and so on. I want to know if they have looked into the independent history of Khelobedu out of the empire of Khalanga or Vulozi. Thank you.
Kuso?
Thank you very much. With the last submission we did, there was a resource that actually does touch on the history of Balobedu as they come down, and I think that was prepared by Khutazo. Maybe Khutazo, just a few pointers from that that resource, particularly to try and address the question that's being put forward by the chair.
I think that research was mainly tracing down the history as well as changes to the language itself. So oral history as well as other historical paper trace the origin of Balobedu to the Vurozi kingdom in Vukaranga, which would be somewhere in present-day Zimbabwe. So these people, Barobedzi or Barozi, they spoke a Karanga dialect, and then in their migration down south, they interacted with Bangona, and that is how they acquired Bakwebo and Nengwekuru, and then they formed a language that was akin to an early form of Venda, But when the Masingo came and conquered the Bavenda, so the two languages separated and became autonomous, they could no longer be regarded as variants of the same language, because the Masingo then came with a different, or rather additional features into the Venda language, while Khelobedu did not have those features at all, as I've said earlier on. And then later on, this Khwebo dialect, which was spoken by the group that the Khelobedu Kingdom, and then was influenced by the surrounding northeastern Sotos to take the final form of the language that we know as Khelobedu today. So the historical interaction between Bapedi and Khelobedu comes later on. So to regard Khelobedu as a dialect of Pedi would be erroneous, because it was not even a direct influence, it was an indirect influence via Setokwa and your languages of Balaudi like Setswapo into Khelobedu, because at that point, like kingdoms such as Bakhaga were modeling their kingdoms based on the kingdom of Mojaji, and that's how influence of Kipedi ended up penetrating into the Khelobedu language. I don't know if that answers the question completely. Thank you.
Thank you very much. Prof, are you assisted?
No, I'm assisted co-chair. Thank you.
Let me give it back to you, Kutso. Any other thing that you think members might have not grabbed on it in your conclusion remark?
Thank you, Chair. From my side, I think we've tried to put the case forward. If members still have questions, we are more than willing through email to still engage to provide a bit more clarity. But also, I'm not quite sure if some of my colleagues wanted to add something else in closing.
I know, Level, I think you've covered everything.
Nothing from my side, Chair. We just want to thank the opportunity.
Okay.
Nothing also from my side. Thank you for the opportunity. If anything else is needed, please do contact us. We'll be more than willing to assist. Thank you.
Okay. Through you, Kutso, thank you very much for this detailed presentation. You have also educated us in terms of this language. And actually, you said one thing to us: we must go back and study our roots. We really appreciate it. We will definitely look into this matter, and the committee, when it meets, we might be engaging with you now and then until we come to finality of this issue, either by email or sometimes, if need be, we can still invite you to such platform and come and clarify to the committee whatever members might need at that time. Thanks for the presentation, the material, and everything else that we have compiled for the committee. I know it's quite a detailed material. We will definitely take it into account, whatever that has been said. The committee is in a mission of trying to finalize 1 or 2 or 4 of these all long outstanding matters before the end of this term. So thank you very much once more. I will ask the members that are in the platform to remain behind while Kutso and his team are leaving the platform. Thank you once more again. Doctor?
Thank you. Cheers.
Anything to say? I'm a co-chair here. Now the other chair is here. You want to say anything, Chair, to the group?
Co-chair.
Yes, Chair.
I missed a larger part of the meeting, so I will be a silent co-chair. Proceed.
Okay. Thanks so much, Kutso. and the entire team, you may just give us a space in the platform to discuss few things with the members. Pilot, are you there?
I'm here, Chair. There is only yourself and the co-chair, as well as Honorable Malika. Those are the only members. The other member logged off. So, Chair, that's about it. We've got PMG that is still with us. So I don't know if they have to be here if we are to discuss internal committee. But so we are.
Yeah, because we are still going to deal with the other members. Maybe let's try to see if everybody else if our presenters have left the platform.
No, they have left, Chair. Everybody has left, yes.
Everybody has left. No, thank you, members, for especially let me start with the administrators, administration, for putting together all this material. Members, we have come to our last briefing. I think, members, now without a waste of time, we need to, I propose that let's have a meeting, virtual meeting next week or so that we conclude with all the deliberations that we have we receive, to allow that our crafters of the report to find time now to consolidate all these matters, and also to see as to which one we call it low-hanging fruits as we go for the second term. At least we need to resolve one or two members of these issues. That's my feeling. Let me put it on the platform. You members, what's your view? Because just to take decision on the outstanding issue, it will take us not more than 30 minutes, colleagues. That's why I suggest that sometimes next week, consult and ensure that all these matters we put together so that we allow the administration to deal with its work, also to allow them space to find time to add up everything in time.
Co-chair.
Yes, Chair. You are loud and clear.
In agreement with you, I think for too long, we conducted ourselves as if we are parliament, not a committee of parliament, and also lost sight of the fact that whatever recommendations we come up with still have to go to another committee. So what you are proposing will actually help us to advance so that recommendations which go to the other committee go there, and that these matters end up in the hands of Parliament itself, because that is the body that must take decisions. Because we spend time considering legal opinions and things like that. And for the purpose of Parliament, it may even appear as if we don't exist, because if you are a committee, you can't even produce recommendations, is as good as not existing. So your proposal, Co-Chair, I think is progressive and it takes us forward. And I suggest that members should consider it seriously. I'm done.
Thank you so much. Thank you so much, Prof. And I think how practical it is possible, Pilot and Sisanda on the platform, here are the issues.
Good afternoon, chairpersons and the members of the committee. Chairperson, I welcome your suggestion. However, I noted that in the MENCO pilot did note that we are starting with the constituency period So of course, you will have to speak to the special application that needs to be made for members to sit during that period. However, the report, it can be drafted now, which speaks to the matters that the committee has processed, and the members just need to then decide the recommendations which they would like to make to the Houses of Parliament in order for them to, for Parliament to decide which matters they're going to be taking forward. And so, Chair, I am in agreement with you with your suggestion. Thank you, Chairpersons. Thank you, members.
Okay. Island.
Thank you, Chair. From my side, I also agree with your proposal, but to qualify that any other meeting that must take place between now and when the second term resumes, it will have to go via the office of the chief whip, because this meeting that you are proposing will be during constituents. So sometimes they normally wouldn't allow committees to meet unless there are serious issues that are before the committee. And secondly, if ever we don't commit, it will also be on the leadership of the committee to ensure that the meeting is attended to, because even if you see today, we only had 2 members, and if we have got 2 or 3 members, there is nothing we can do in terms of taking decisions, because then that will need a quorum. Thank you.
So the issue is about asking a special permission from the chief whip, because this meeting, we are not flying to Cape Town. It's a meeting that is fully virtual, where just to inform members, we want to take the decision, we want to make a recommendation on these matters. We finalize the minutes so that the report can be start crafted. Come the beginning of the new term, we already have got a report so that we can also be able to submit them. I think these matters are also matters of agency. As far as I'm concerned, I'm not sure, members. Other committee meeting, they sit even at 6 o'clock. I don't know how are they doing, but you have been in the NSOP, we have been sitting in meeting until others at 9 sometimes. Because this meeting of just processing this report presentation, it won't take us more than an hour. If that can be stated and say, no, we just need an hour or so for members to log on, maybe Tuesday or Wednesday, sit down, finalize, process this thing, and just get done out of it. I don't know, pilot, what really requires us to do. Co-chair?
Sorry, Chair, can I come in also? It's just I don't know what's wrong with my gadget. I can't raise my hand.
Yes. Maleka?
Thank you, Chairperson. Yes, Chairperson, I support your recommendation. The issue that I think Khelobedu is raising now is a challenge, because you see today, we only 3 members here, and we will need maybe a quorum for the recommendations. If maybe we can if he can put on the group that we check the availability, and the members must be aware that is an urgent meeting, and as you said, it's not even going to take even more than an hour, that maybe if they avail themselves, because it's not a physical meeting, it will be virtual. I don't think maybe the recess can even affect that, but we can do the processes, follow the procedures that must be followed, that we can handle that meeting. Thank you, Chairperson.
Thanks, Maleka. Prof, you have already pronounced on the matter. Doctor, Prof Matona? Co-chair? Okay, members, otherwise, thank you very much. Let's try pilot for this meeting and see if we can do it sometimes next week. Send the necessary application or also information to our group and let's raise the state, the agents of this meeting, because colleagues, I still feel that it will help us that during our research, we allow a process of crafting of the report, having gone through all what is required from us. Actually, it's us members that are delaying the process. Yes, Prof.
Prof, if you allow me, I wanted to suggest that for too long we have been quiet, that maybe at the end of this meeting, we issue a statement to say we still exist, we are seized with the following matters, so that we begin to publicize the work of the committee. But also, I was on the 27th, I met with the DG of Justice, and he asked me to extend a special gratitude to yourself for leading a delegation to the conference. And he is also asking for a meeting with our committee, because they believe that this committee is critical for doing the work, the constitutional review work, not only on the basis of what is submitted by the public, but that they themselves as government, they have issues which they think could be processed through the committee. So I'm just leaving that in your good hands to see how that matter can be taken forward as the leader of that delegation.
Thank you very much, Doc. Professor, on that matter, I think it is doable, Professor, especially in our meeting, if we can arrange that the DG come in that meeting and work through pilot to raise those issues that he wants to raise with the committee. He's welcome. We can give him that space, and thereafter then finalize our report. I'm definitely sure, Chair, what is left with us is just quite 1 or 2 minutes to resolve on those issues.
Thank you.
Colleagues, thank you very much. Anything from the administration point of view? I will start with you, Pilot.
Thank you, Chair. I am covered. The issues are noted, Chairperson. Thank you.
Including the coordination of the next meeting soon.
That's correct, Chair.
Okay. Sisanda?
Thank you, Chairperson. I'm also covered and understand. Thank you, Chair.
You'll forgive me, I abuse you because sometimes you are a researcher, you are a content advisor, you are everything in this committee. I find time to abuse you.
She's the Almighty. She's the Almighty.
Members and colleagues, this meeting adjourned for today. Thank you very much for your participation. And yes, we will meet soon. We will hear from Pilot. He is going to communicate to all of us the progress as to how are we solving out these matters as a matter of urgency, those that are outstanding. Thanks once more again for your attending into this meeting. This meeting stands adjourned, colleagues.